Health Insurance Proclamation revoked. EOIR will start hearing cases again in July for non-detained individuals. Green card holders are being kept out of the US and may lose their green cards. A win for one of our clients and more in immigration news. Keep watching to find out how you and your immigration journey might be affected by everything that's going on in immigration in the US today. My name is Mejer, and I'm an immigrant and an immigration attorney. In a recent TV appearance on Fox News 40 in Sacramento, I explained how I came to the US as a child and learned English from watching Sesame Street. My family hired an attorney to get us legal status, but they did nothing. And I spent almost a decade without legal status. So I know how stressful it is on individuals and on families because I went through it myself. I went to law school and became an immigration attorney to help people like me and my family, and maybe people like you, avoid the stress that my family had to go through. Call us if you need help with an immigration issue. We're here to help. Okay, let's first talk about the Health Insurance Proclamation. What does that mean? A while back, I talked about that you needed health insurance as an immigrant to the United States. It was very expensive. There was a 2019 proclamation issued by the president at the time that required immigrants to prove they would get qualifying health insurance within 30 days of coming to America or have the resources to cover medical costs. Former President Donald Trump's White House had said the proclamation was aimed at protecting healthcare benefits for American citizens. Biden has now reversed that proclamation. For those who will be screaming that we don't want people coming to the US who are only going to take, keep in mind, this in no way removes the requirement that people are able to afford to take care of themselves or that their sponsor will do so if they get any government help. President Biden said, "My administration is committed to expanding access to quality, affordable health care. We can achieve that objective, however, without barring the entry of non-citizens who seek to immigrate lawfully to this country, but who lack significant financial means or have not purchased health insurance coverage from a very restrictive list of qualifying plans." There is another Trump proclamation that Biden recently ended. I think it's important to mention. This one doesn't impact as many people, but it still was concerning. Don't forget, there are over 400 policy changes Trump made to immigration that need to be reversed or at least reviewed. There was a Trump-era policy put in place by Betsy DeVos that kept undocumented college students from receiving federal relief grants, meant to help pay for expenses like food, housing, and childcare during the coronavirus pandemic. The DeVos rules said that the colleges could provide federal COVID relief funding only to students who qualify for federal financial aid. That definition excluded undocumented and international students studying in the United States. 3 federal judges in different parts of the country struck down DeVos's restrictions on the funding, but these court rulings applied only to colleges in Massachusetts, Washington State, and community colleges in California. Education Secretary Miguel Cardona finalized this new regulation that now allows colleges to distribute tens of billions in federal pandemic relief grants to all students, regardless of their immigration status or whether they qualify for federal student aid. Secretary Cardona said the pandemic didn't discriminate which students got COVID, so the final rule allows for all students to access the funding. The goal is to make sure that all students have an opportunity to have access to the funds to help them get back on track. Another presidential update I want to talk about. I was recently interviewed by Straight Arrow News where I discussed the heartbreaking news stories of children as young as 2 going to immigration court by themselves, not speaking English, not understanding what was going on, not having an attorney to help them. On May 18, 2021, the president signed a presidential memorandum to expand access to legal representation and the courts. The proclamation says the federal government has a critical role to play in expanding access to the nation's legal system and supporting the work of civil legal aid providers and public defenders. President Biden's executive action today will reinvigorate the federal government's role in advancing access to justice and help ensure that the administration's policies and recovery efforts can reach as many individuals as possible. This is supposed to include access to attorneys for those in immigration court. Keep in mind, this is not saying there will be attorneys for everyone in immigration court, but that there will be studies of how this can happen, as well as increased funds for public defenders and other justice agencies around the country. So far, it sounds like a lot of talk, Whether it actually amounts to anything, whether it'll be a noticeable change, only time will tell. I, for one, hope that it is used to help immigrants, and particularly the children. Now, let's talk about more immigration news. H-1B holders got great news from the USCIS on May 18, 2021. It vacated the final rule regarding H-1B specialty wages. DHS tried to put this new rule into effect back in October 2020, but a California court said they couldn't. Now, DHS agrees. The government has formally removed the regulation that would have redefined an H-1B specialty occupation. It would have restricted the off-site replacement of H-1B employees and increased employer compliance requirement. Basically, it would have made it much harder to qualify, much harder to keep. It was not immigrant friendly. It was not employer friendly. It was not employee friendly. It wasn't good at all, unless you hold and you believe that there shouldn't be immigration. That's the only group that would have benefited from that change. This most recent rule removes the regulatory text that DHS published in the vacated October 2020 federal court rules and restores the regulatory text to appear as it did before the October 2020 rule was issued. So basically, applying the old standard, removing the new one. In mixed news, the Department of Homeland Security wants military members to stay at the U.S.-Mexico border past the September 30 date they were expected to return home. About 4,000 National Guard troops are currently at the southern border as part of a mission that began in late 2018 and was meant to end by the start of October. But on May 12th, DHS requested the Defense Department extend Department of Defense support to Customs and Border Patrol into fiscal year 2022. The department is currently considering that request, Pentagon spokesman Lieutenant Colonel Chris Mitchell said in a statement. Past presidents, not just Trump, have sent troops to the border. This is nothing new. What was unusual was that President Trump declared a state of emergency to get funding for his wall and sent troops there. Biden has ended the emergency so the troops, one would think, would return home. It will be interesting to see how this plays out and impacts processing of immigrants at the border. County jails are being shut down as immigration detention centers and their practices are being reviewed due to allegations of abuse and neglect. In a memo to ICE directing the changes, Mayorkas said his foundational principle is that we will not tolerate the mistreatment of individuals in civil detention or substandard conditions of detention. We have an obligation to make lasting improvements to our civil immigration detention system, Mayorkas said in a statement. This marks an important first step to realizing that goal. DHS detention facilities and the treatment of individuals in those facilities will be held to our health and safety standards. Where we discover they fall short, we will continue to take action as we are doing today. The facilities being closed and reviewed are in Georgia and Massachusetts, but it is expected this review will expand to other states as time goes on. In New Jersey, Essex County Jail has decided to terminate its agreement with ICE. All immigrants will be removed by the end of August from this location. This jail is the largest immigration detention center in the state of New Jersey. Although I agree in principle with the closure, the practical effect is that ICE will move detainees to other parts of the country where their family will not be able to see them, and they are less likely to have access to attorneys. The move that we are seeing nationwide is attacking the symptom, immigration detention, rather than the cause, the lack of viable immigration reform of the courts and a path for legal status for undocumented immigrants in the U.S. Moving immigrants detained in New Jersey to places outside of New Jersey does not benefit the immigrant and does not benefit the immigrant family. It only will allow the government to move people and create large courts in areas where there are few attorneys and bring them in by video, and life will be worse for immigrants, not better. I hope this trend changes. EOIR is restarting hearings for non-detained individuals. On July 6, 2021, the Executive Office of Immigration Review, that's the courts, plans to resume non-detained individual, or let's say trials, and master calendar hearings, which are more like status conferences, in limited numbers at the following immigration courts and consistent with the applicable health and safety protocols. Now, the list I'm going to give you now is not the list of closed courts. All courts are still seeing detained individuals. That hasn't changed. Now, there are courts that are seeing people who are not in a detention center. Some of them were closed. The following are gonna be open for, again, non-detained cases. So we're talking about someone that was released from detention or was not in detention, but is being removed from the United States. So Dallas, El Paso, Fort Snelling, Harlingen, Houston Greens Point Park Drive, Houston South Gessner Road, Kansas City, Memphis, New York Broadway, New York Federal Plaza, New York Varick, Portland, San Antonio, and San Juan. For cases scheduled from July 6th through July 20th, parties or their representatives who entered an appearance with the court in a case, like an attorney, who have not received a notice of a reset hearing by June 22nd should plan to attend their hearing as scheduled. All parties, including those with cases scheduled after July 30th, should continue to rely on official notices from the immigration courts as the best source for information regarding the hearings. But don't forget the 1-800 system, and you can also check online. Please note that the option to file by email at the mentioned courts will end on September 4th, 2021. Sure, why continue something that's working when you get ended? Thank you, government. Emails sent to these courts after September 4th, 2021 will not be reviewed, and email filings will not be accepted without specific permission and instruction from the immigration court. Contact information for immigration courts nationwide is available on EOIR's website when it's up. Green card holders are being kept out of the US. If you have watched my channel at all, I've told you, do not stay outside of the US for longer than a year if you are a green card holder. In reality, you should not be out for longer than 180 days. Why? Because if you do, USCIS may take the position that you abandoned your green card and may not allow you to re-enter. Then the pandemic happened and people couldn't travel. So now hundreds or thousands of green card holders have been outside the US for over a year. And if they don't apply for a re-entry permit before leaving and can't apply for a returning resident visa because the consulate or embassy isn't open, they may lose their green card. What should you do if you are one of those green card holders outside of the US? I recommend you still try to travel back to the US as soon as possible and have lots of evidence why you could not re-enter the US sooner. Be sure it shows that you tried, but there were circumstances beyond your control, such as canceled flights or closed airports. Some airlines aren't letting green card holders fly, saying they violated their status. If that happens to you, you need to contact the supervisor at the airline and the CBP liaison and get a written letter from CBP to allow you to board the flight. There's actually a related issue to this for US citizens who are overseas. How many times have I given you an update on an embassy and consulate opens? Well, unfortunately, if they aren't open for immigrants, except for emergencies, they typically are not open for US citizens either. Now, many consulates remained open only for US citizens in emergency situations. But again, it does vary by embassy. So that means US citizens who have a passport that is expiring and or expired, may have a hard time getting an appointment. This might seem like a little issue, but it's impacting over 100,000 people. There are 9 million US citizens living abroad. So you got to take a look at your local embassy or consulate. You may have to travel further than you would have liked just to get your passport renewed. As of April 2021, 75% of embassies and consulates are still closed. In Jerusalem, there are over 15,000 passport applications backlogged. In Mexico, which has the largest number of American expatriates in the world, they are not scheduling any appointments at the US Embassy in Mexico City. This also impacts people who have a child that want to register them as a US citizen. So if you're a US citizen born abroad and you have a child, your child is also a US citizen, but you need to notify the Department of State at the embassy or consulate. You need to fill out a form and your child will get what's called a certificate of citizen born abroad. They're not open, it's a little hard to do that. If you're trying to renew a passport within the US, send it in and know it will take about 10 to 12 weeks. I recently had to renew mine, and even with expedited process, it took me over 5 weeks. I came close to missing my flight. So what can you do if you are a US citizen outside the US and your passport is about to expire? Travel to the US before it expires. Every US embassy has an online system. Check it daily. They might have an appointment open, but you must check it every day. There are broker services in foreign countries that may be able to help you get an appointment. They may be able to help, though there is no guarantee, of course. Let's end today talking about a win for one of our clients. She entered the United States as a child under her father's I-130 approval petition. That's a family-based application. In other words, someone applied for a father and she was included as his dependent because she was under 21. The petition took many years for the approval and for a visa to become available. Unfortunately, during those years, the petitioner, that's the person that applied for a father, died. Her father failed to notify USCIS and the Department of State of the death of the petitioner. What that means is the petition should have ended with the death of the petitioner. But because the fact wasn't disclosed, her father and the rest of her family were allowed to enter the United States. Now, maybe they weren't asked. Maybe they just lied, it could be either one of those situations. Her father and family should never have received the permanent resident cards, but it certainly wasn't her fault. She was a minor. Now, years later, she filed for U.S. citizen, and this fact came out because remember, I tell people this on a regular basis. When you're filing for citizenship, it's the government's last opportunity to say, hey, either you lied to us or we made a mistake, and they could try to take away your green card. And that is something they were considering doing for her. The position from the government is she was not lawfully admitted because her green card should not have been issued. However, it was not her fault. The government could have put her in removal proceedings, but I'm happy to share with you that we were able to help her avoid removal and get her citizenship. And now we hope to help the rest of her family. So again, keep in mind, when you're filing for citizenship, obviously you have to have the requirements. You have to be over 18 years old. You have to have been a green card holder long enough. You have to be a good moral person. You have to pass the civics test, and you can't have any of the things that could disqualify you. Well, when you meet all the requirements and you are a good moral person, the last thing that the government checks is, were you lawfully admitted into the United States? Either you lied about something, or something wasn't disclosed, or the government made a mistake. It might be as simple as they put you in as the wrong category because you were married and then got divorced, or you were single and then got married, whatever that is. Or in this case, the petitioner died. This is their last opportunity to put you in removal proceedings. So some people think filing for U.S. citizenship is simple and easy. Certainly, this woman did as well, until she had a problem, and then she reached out to us, and fortunately, we were able to help her. If you need help getting legal status or U.S. citizenship, call us. If we can't help you, we won't take your money. Thanks for watching. As always, stay healthy and be well.